Move that old rock. Nobody wants to see that ugly thing at the entrance to my driveway.
Tansy Whitlock Shaw said it to her paving foreman while pointing at the 1863 granite survey monument my great-great-grandfather Cornelius had set at the corner of our farm road. The foreman radioed his excavator operator. One tip with a steel bucket and a 160-year-old stone went into the drainage ditch with a splash. Then her crew poured 300 feet of hot asphalt across my family's agricultural haul road, installed a wrought iron gate reading Shaw Family Residence, and set up a porta-potty where my father used to park his tractor. My 16-year-old son, Piet, who has Asperger's, was standing at the end of the road when I pulled in from a 3-day conference in Lansing. Tansy thought she had just saved her architect $180,000 on a wetland driveway. She didn't know I am Michigan's leading right-to-farm defense attorney, and the road she just paved is officially registered with the state as an agricultural haul road. What would you have done? Where are you watching tonight? My name is Owen Vandermeer. I'm 52 years old. I farm 480 acres of cherries and apples in Oceana County, on the western side of Michigan, and in my day job, I practice agricultural law at a small firm in Hart. My specialty, which matters to this story, is Michigan's Right to Farm Act. The Vandermeer family came to Oceana County from the Netherlands in 1867. My great-great-grandfather, Cornelius, bought 160 acres from a bankrupt homesteader and planted his first block of cherries the following spring. The farm doubled twice. My great-grandfather added the lower orchard in 1904, and my grandfather added the east block in 1952, and came to me when my father Dirk passed 8 months ago in the barn of a heart attack on a cold December afternoon. I found him. I think about it every day. I am still not over it. My wife Henrietta, Henny to everyone in Shelby, is a registered nurse at Hart District Hospital. She works 3 12-hour shifts a week and makes the best apple fritters in western Michigan. We have been married 27 years. We have 2 children. Our daughter Elsa is 21, a junior at Michigan State University, studying horticulture with a specific plan to take over the cherry operation when I am gone. Our son Piet is 16, a high school sophomore, and has Asperger's. He is a quieter version of me, with a brighter version of my father's smile. He grafted 40 Honeycrisp apple trees by hand for a 4-H project 2 years ago, and can tell you the budwood source of each one from memory. The farm road that matters to this story runs due east from our county road access, 100 yards through a row of old Norway maples my grandfather planted in 1953, past the granite survey monument my great-great-grandfather Cornelius had quarried out of Grindstone Island and hauled here by oxen in 1863, and into the heart of the orchard. It is gravel. It has been gravel since Woodrow Wilson was in the White House. In 2009, with my father's permission, I formally registered it as an agricultural haul road under Michigan's Right to Farm Generally Accepted Agricultural and Management Practices Documentation System, file number RTF-MI-2009-01847. The registration matters later. Next to our farm, on the north side of the county road, sits a subdivision called Orchard Ridge Estates. It was built in 2018 on 140 acres of land that used to belong to the Feltenberg family. Abel Feltenberg went bankrupt in 2017 after his blueberry operation failed and sold to a Grand Rapids developer. 62 executive homes now sit where his plants used to be. Some of the homes are nice. Some of the families are nice. I have never had a serious problem with any of them. They jog on my farm roads sometimes. My father always waved. Then, 14 months ago, Tansy Whitlock Shaw moved in with her second husband, Byron. She was 48, had just left a previous marriage in Grand Rapids, and bought one of the largest lots in Orchard Ridge, 4 acres, backing directly onto the western edge of my land. She built a $400,000 custom home over the next 10 months. Her lot's one access problem. It fronted only on the subdivision's interior road, which meant any driveway connection to the county road required crossing 150 feet of protected wetland. Her architect quoted her $180,000 for a compliant wetland crossing driveway. She declined to pay it. She looked at a map. Then she looked at my farm road. I was in Lansing for 3 days at a Right to Farm conference, a panel I sat on with 2 other defense attorneys, a judge from the Court of Appeals, and a Michigan State University extension professor. I got back Thursday evening at 6:30. Piet was at the end of the farm road in his work coat, pacing in a small circle, with the measured, anxious pacing he does when something he cannot process has broken his routine. "Dad." "Piet, what is it, son?" "Dad, come look." I walked. My eyes took a long time to understand what they were seeing. 300 feet of fresh black asphalt, still glistening under the porch light I had not yet reached. A 4-foot wrought iron gate swinging wide open at the entrance, with Shaw family residence in ironwork script across the top. A blue porta-potty planted exactly where my father used to back his tractor to load half-bushel boxes of peaches for the farmer's market. And at the corner where the old Norway maples begin, the granite survey monument, 400 pounds, hauled here by oxen 162 years ago, was on its side in the drainage ditch, with mud on its face. I set my briefcase down on the gravel. "Piet, how long have you been out here, son?" "2 hours. Is your mom home?" "Yes, she's crying in the kitchen." "Okay, you and I are going to put the stone back up together." The monument weighed roughly 400 pounds. It took us 42 minutes. Piet counted, because Piet counts. We used the come-along, 3 pine 2x4s, a tire iron, and the old tow chain my grandfather had bought from a co-op in 1971. When we got the stone back upright, roughly level, on the original concrete pad my great-great-grandfather had poured in 1863, Piet stood back, looked at it, and said, "Dad, it looks right." "It does, son." At that exact moment, a cream Range Rover pulled into the top of the farm road. Tansy Whitlock Shaw stepped out in a pink fleece and a Lululemon headband. She walked over with a small, apologetic hand wave, as if we'd just had a comedic misunderstanding about a parking spot. "Owen, you're back." "Oh, you moved the rock. We were actually trying to preserve it by storing it in the ditch until we could reposition it properly. Anyway, we should sit down sometime soon and discuss the driveway arrangements. Don't be difficult about this." I looked at her for a long moment. Piet, I noticed, was watching his shoes. "Mrs. Whitlock Shaw, please leave this property." "Owen, we are neighbors, and—" "Please, leave." She left. That night, after Piet was in bed, I sat at my father's kitchen table with a yellow legal pad, and Henny across from me with a cup of chamomile tea. "Honey, are you going to fight this?" I looked at my wife across the same oak table, where my great-grandmother had shelled peas in 1928. "Henny, I am going to close it out, quietly. Entirely." She nodded once. She got up. She refilled my coffee. She put the pot back on the stove and she said, without turning around, "Good, your father would agree." I drafted the cease and desist letter that night. 3 pages, Vandermeer Agricultural Law letterhead, signed in my own hand, certified mail next morning. Paragraph 1. I am the fee simple owner of the land on which you have constructed a trespassing asphalt encroachment. Paragraph 2. The road in question is a registered agricultural haul road under Michigan Right to Farm Act, GAAP documentation. Paragraph 3. Remove the asphalt, the gate, the porta-potty, and any materials within 48 hours, and we will discuss damages privately. Fail to do so, and you will be dealing with my firm, my colleagues at the Michigan Farm Bureau, and every regulatory body in the state that has jurisdiction over agricultural protection. Tansy's response, 9 days later, came on letterhead from a Grand Rapids firm I had never heard of. It asserted that my farm road was actually a shared common access driveway under Michigan's Land Division Act, specifically citing MCL 560.254A, which she had misquoted by inserting a phrase that does not exist in the statute. It further alleged that she held an implied easement by decades of HOA resident use. Finally, it threatened a criminal harassment charge against me for obstructing access to her female residence. I read the letter twice. I walked it out to the barn. I placed it in the bottom drawer of my father's old oak tool cabinet, where he had always put the things that needed to wait until morning. Then I began to prepare. Michigan's Right to Farm Act, passed in 1981 and strengthened 4 times since, does something extraordinary for farmers that most people never learn about until they need it. It preempts private nuisance lawsuits against compliant farm operations. It bars local zoning ordinances that would restrict standard agricultural practices. And, this is the part Tansy was about to encounter the hard way, it entitles compliant farmers, when sued in bad faith, to full, reasonable attorney fees and costs, recovered from the plaintiff. The takeaway you should save. If you farm in Michigan, Iowa, Wisconsin, Indiana, Ohio, Illinois, or any of the 38 other states with a right to farm statute, Your legal protection against nuisance suits is far stronger than your neighbors realize. Read your state's exact language. Keep your GAAP documentation current. You will, someday, need it. I formally invoked the act in a second letter to Tansy's Grand Rapids attorney on Tuesday morning. I copied the Michigan Department of Agriculture and Rural Development. I copied my firm's senior partner, Ellery Ray Bostwick, a 73-year-old man who had spent 40 years writing briefs for the Michigan Farm Bureau, and who, when I called him that afternoon, came out of semi-retirement in exactly the way a bird dog comes out of a nap when the shotgun comes off the wall. Tansy's response was to escalate. On Friday morning, her landscaping contractor, a different crew from the paving company, from a different county, sprayed glyphosate along the shoulder of the farm road to beautify the driveway edge. The herbicide drifted. It drifted into the first 30 feet of my West Honeycrisp block, where 46 trees stood in full leaf out, 3 weeks from bloom. Piet saw the damage Saturday morning at 7. He walked into the damaged block. He counted affected trees. He photographed each one. Then he sat down in the grass between rows 12 and 13 and cried the quiet kind of crying he does, which is not loud, but which I can see from 100 yards across a pasture. Those 46 trees included the 40 honeycrisps he had grafted himself 2 summers earlier for his 4-H project, with budwood from my great-grandfather's original 1942 plantings. The Aldi contract for that block, negotiated last fall by my father 3 weeks before he died, was worth $140,000 for the 2026 harvest alone. I walked out and sat beside my son in the grass. I did not speak for about 6 minutes. Then I said quietly, "Piet, I am going to need your help on this." "Dad, I already started counting." "I see that, son. That's exactly what I need." We spent the rest of Saturday documenting damage. Piet, with his Asperger's level focus, produced a document over the next 4 days that I could not have matched with 3 paralegals and a drone. A 47-page GPS-tagged, photograph-dense tree-by-tree damage report, with suspected drift concentrations calculated from wind patterns and distance from the spray line. He signed it, at my suggestion, as the primary field investigator. It would, 6 months later, become Exhibit B in a very serious courtroom. Monday, I called the Michigan Department of Agriculture and Rural Development's Pesticide Enforcement Division. A 54-year-old field investigator named Patrick Nels drove out Tuesday afternoon. He walked the damage with Pete as his guide. Pete handed him the 47-page report, spiral-bound. Patrick Nels read it standing in the orchard. He took off his hat. He said to Pete, "Son, this is one of the best drift reports I've ever been handed. You did a fine job." Piet did not quite know what to do with his hands. Tuesday afternoon, Tansy and Byron came out of the Shelby IGA with 2 bags of groceries as I was pushing my cart in. Tansy saw me, stopped, turned to her husband and said loudly, "Oh, Byron, there's the passive-aggressive widower farmer. He's probably spent his whole weekend writing us another little letter. Haven't you, Owen?" The produce manager, a 51-year-old woman named Delphine Ox, who had known my father for 40 years, stopped stocking tomatoes. She stared at Tansy with the face women develop when they have seen one too many Tansies in a lifetime. I did not answer. I bought my sweet corn. I held the door for Delphine Oaks on the way out. In my truck, I wrote down the date, the time, the witnesses, and the exact phrasing she had used about me. I was starting to fill up my small notebook. By the following Monday, I had learned that Byron Whitlock Shaw, Tansy's husband, had played exactly 1 round of golf 3 weeks earlier at the Muskegon Country Club with a 64-year-old man named Arthur Penrose, who happened to be the chairman of the Oceana County Road Commission. My Department of Agriculture complaint against the herbicide drift had arrived on a desk. My soil erosion and sedimentation complaint against the unpermitted asphalt driveway had arrived on a different desk. Both had been forwarded, in ordinary course, to Arthur Penrose's office for county coordination review. Both, within 3 business days, had been marked administratively paused pending additional information. Ellery Ray Bostwick read the emails, put down his reading glasses, and made 1 phone call to a state representative named Gretchen Teague, whom he had helped elect 3 times, and whose uncle had been a Vandermeer neighbor in the 1960s. 10 days later, the 2 paused cases were reactivated, with the notation, County Coordination Review complete. Arthur Penrose was not returning Byron's calls. A knowledge nugget worth pinning. In Michigan, as in most states, Agricultural regulatory cases that get paused by county officials are subject to direct supervisory review by state-level agencies. If your county is quietly helping your bad neighbor, file a parallel request for direct state action. The state does not like being slow-rolled by the county. It will remember. Tansy, meanwhile, filed a civil nuisance suit against me in the Oceana County Circuit Court. The complaint alleged that my orchard's fermenting fruit odors, agricultural equipment noise, and pesticide chemical exposure constituted a private nuisance under Michigan common law and diminished the quality of life at her half-built residence. She requested injunctive relief, a permanent restriction on my farming practices, plus $100,000 in quality of life damages. I read the complaint in Ellery Ray's office. I set my coffee cup down very slowly. I looked across his oak desk at my 73-year-old mentor, who was smiling the small, dry smile of a man who had waited 45 years to see a specific kind of legal pleading walk into his courthouse. Ellery Ray. Owen. She has just filed a civil nuisance suit against the compliant Michigan farm operation. She has, which, under Right to Farm Section 3, is preempted. It is, which entitles me to recover full, reasonable attorney fees and costs from her under Section 3.6. It does, which, given your billable rate and mine, and the fact that we are jointly handling this, will run approximately $250,000 by the time we're done. Yes. Ellery Ray. Yes, Owen. She has just handed me $250,000. Ellery Ray closed his eyes for a moment, the way old Lutherans close their eyes at the beginning of a grace, before a very large meal. Son, let's be thorough. 2 nights later, my mailbox was destroyed with a baseball bat at 1:12 in the morning. The motion camera caught a navy blue Ford F-150, license plate visible, driver visible. The driver was Byron's nephew, a 24-year-old named Tyson Whitlock, who had 2 previous citations in Kent County for property mischief. I filed a vandalism report with the Oceana County Sheriff at 6 in the morning. Tyson was brought in for questioning by Thursday. He asked for a lawyer. As he was being escorted out, he said, loudly enough for the deputy to log it, "My aunt's paying me. I'm not taking the fall." Sheriff Trinity Forsberg, who had fished with my father in 1978 off a dock that no longer exists, called me personally at lunchtime to pass along Tyson's statement. Then she added, "Owen, we're opening a separate file on your neighbor. Don't quote me." I did not quote her. That night, Piet came into my office while I was working at my father's desk. He had his damage report under his arm. He set it carefully beside my keyboard. He said, "Dad, I'd like to be a witness. If they put me on the stand, I'll tell the truth." "Son, you already told the truth on paper. I mean on the stand, in court, with the judge." I looked at my 16-year-old, at the hair that stuck up the same way his grandfather's always had, at the shoulders that had widened 2 inches in the last year. "Okay, Piet, if we need you, we'll use you. Thank you." "Dad, also, I've been counting the asphalt she poured. It's 327 linear feet, not 300. I measured it myself." "That's helpful, son." "I know." After Piet went to bed, I opened my father's filing cabinet in the corner of the farm office, the one labeled in black Sharpie, Road, and I began laying the pieces on the desk. 4 documents, side by side, told me what I already knew but had never, until this month, needed to know. First, the 1867 original deed from Cornelis Vandermeer, conveying 160 acres of Oceana County farmland, together with all haul roads, cart paths, and agricultural improvements therein described. The deed lists the farm road by compass bearing, and explicitly excludes any shared right-of-way, easement, or common access. The farm road is ours. It has always been ours. It is not, has never been, and will never be a common driveway. Second, a Michigan State Turnpike alignment map from 1854 that I had pulled from the Michigan State Archives in 2009 when I was helping my father with a boundary dispute. The 1850s Michigan Turnpike from Muskegon to Pentwater ran, for its final 2.5 miles, directly along what became our farm road. The state turnpike was formally abandoned by the legislature in 1872. Michigan Statute, MCL 247.190, provides that abandoned state turnpike rights-of-way revert automatically and permanently to the underlying landowner, meaning Cornelius's farm road is not only a private agricultural haul road, it is a statutory reversion of a former state turnpike, which carries the strongest form of title Michigan law recognizes. Third, my 2009 GAAP registration of the farm road as an agricultural haul road under the Right to Farm Act, file number RTF-MI-2009-01847, currently active, last reaffirmed in my own handwriting 2 years ago. The registration is public record. Anyone who had looked could have found it in 15 minutes. Tansy's attorney had not looked. Fourth, and this was the quiet one, the one Ellery Ray made me print and place at the top of the stack. Tansy's driveway, because it connected to a residential structure and converted 327 linear feet of agricultural gravel to asphalt impervious surface, required 2 permits she had obtained neither of. A National Pollutant Discharge Elimination System construction stormwater permit administered by the Michigan Department of Environment, Great Lakes, and Energy, and an Oceana County Soil Erosion and Sedimentation Control permit. The first carries civil penalties up to $25,000 per day. The second requires the posting of a remediation bond in the neighborhood of $50,000. The takeaway worth writing on a note and taping to your cabinet. Any impervious surface construction connected to a residential dwelling, in almost every state, requires both a stormwater permit and a soil erosion permit. These are triggered at surprisingly small thresholds, often 500 square feet. Ask your county. The penalties are not small. I set my pen down. I looked at the 4 documents in order. I looked at Piet's damage report beside them. I looked at my father's oak desk. The farm office clock struck 11. Ellery Ray had said, earlier that evening, that I had the cleanest case he had seen in his career. I had not believed him at the time. Looking at the 4 documents now, I believed him. I turned off the desk lamp. I walked outside. The cherry block to the west smelled, in the cool night, exactly like my father. I stood there for a long moment. Then I went inside. I filed the first 3 motions before 6 a.m. Over the next 7 weeks, Ellery Ray Bostwick and I did the work of our professional lives, in the quiet way old Dutch farmers do work, methodically, without drama, and with enough paperwork to burn a barn. We filed a motion to dismiss Tansy's civil nuisance suit under the Right to Farm Act Section 3 preemption, with a simultaneous request for Section 3(6) attorney fees. We cited, among other authorities, the 2018 Court of Appeals opinion in Hall v. Northwood Estates that I had personally argued and won. We attached certified copies of the 2009 GAAP registration, the 1867 deed, the 1854 Turnpike Survey, the 1872 Abandonment Act, and Piet's 47-page damage report. We filed a separate civil complaint against Tansy and Byron Whitlock Shaw for trespass, conversion, negligent destruction of historic property, the Granite Monument, and tortious interference with our Aldi supply contract. Ellery Ray filed the formal EGLE stormwater complaint and the Oceana County soil erosion complaint, both attached with engineering calculations of Tansy's impervious surface to the square foot. The pesticide drift case opened in parallel. Patrick Nels of the Michigan Department of Agriculture issued a preliminary finding within 3 weeks, citing Tansy's landscaping contractor for application outside the permitted buffer zone, with civil penalties calculated at the maximum allowable under statute, a flat $25,000 plus full compensatory damages at $140,000 to cover the value of the threatened Aldi contract. Ellery Ray and I divided the work by temperament. He handled the correspondence with the insurance carriers, the press, and the Michigan Farm Bureau's PR office, because he is 73 and has the energy of a man who has just been handed a cold cup of coffee. I handled the courtroom prep and the client-facing work, because I am 52 and still sleep slightly better than he does. Piet, on his own initiative, organized my office filing system with a color-coded label maker. By the end of the 2nd week, every document in the road case had a tab, a number, and a cross-reference to a master index he had built in a spreadsheet. I came home one evening and found him sitting at the kitchen table, explaining the index to my wife in the same quiet voice he uses for Budwood sources. Elsa drove up from East Lansing on the 3rd weekend, spent 4 days helping us prune the herbicide-damaged block aggressively, and drove back to campus with a decision she had not had the Friday she arrived. On the Sunday night, she told me, at the kitchen sink, that she was changing her major to include an ag law minor. Dad, if someone does this to us again, I want to be able to help. I did not trust my voice, so I just nodded. Mrs. Hilda Pedersen, our 86-year-old Lutheran neighbor to the south, drove her 1994 Buick Century up our driveway on a Tuesday afternoon with a plate of krumkak and a sworn affidavit she had typed herself on her late husband's 1986 IBM Wheelwriter. The affidavit covered 40 years of personal observation of the Vandermeer Farm Road as private agricultural property, including her memory of my father, Dirk, and his one-armed cousin, Arvid, plowing it together with a 1962 John Deere in the winter of 1978. She had signed the affidavit before a notary at her bank. She handed it to me with the plate of krumkak in the same gesture. Owen, your father would be using language right now that I would not be using, but I wanted you to know what I saw. Mrs. Pedersen, thank you. Don't thank me. Eat the krumkak. And win. The Michigan State Historic Preservation Office sent an architectural historian named Dr. Magnus Thorson to document the 1863 granite monument. He wrote a 10-page report concluding that the stone, which was quarried from Grindstone Island sandstone, was one of only 11 known surviving 1860s Oceana County farm monuments, and recommended formal inclusion on the Michigan Historic Landscape Inventory. The inclusion was granted 16 days later. Finally, on the morning of the 7th week, Ellery Ray and I drove to the Oceana County Courthouse in Hart to attend the first hearing in Tansy's civil nuisance suit. She had not answered our motion to dismiss. She had not responded to any of our discovery requests. Her Grand Rapids attorney, we learned in the parking lot from the clerk, had withdrawn from the case the previous Friday for non-payment of retainer. She had retained a new attorney named Barrett Locke from Muskegon. Barrett Locke had never, apparently, tried a right-to-farm case. We knew, because Ellery Ray had trained every defense attorney in the western half of the state. He asked us if we could settle this informally. Ellery Ray smiled his small Lutheran smile. No, son, we'd like to see a judge. Tansy's response to the combined pressure was the response most Karens give when they feel a courtroom closing in on them. She turned to Facebook. On a Friday evening, while Henny and I were watching a Tigers game and eating peach cobbler, Tansy posted a 400-word statement to her public Facebook page under the heading, A Mother's Plea. It began, I am a mother of 3 children and the victim of an aggressive campaign by a local farmer who has decided to destroy my family for my success. It ended, if anyone in our community would like to help us stand up to this bully, please DM me. Henny read it over my shoulder while I was eating the cobbler. Owen, she has one stepson she sees twice a year. I know, honey. The Bar Discipline Committee is going to hang that post on her forehead in 36 hours. Henny was off by 19 hours. The Michigan Attorney Discipline Board, after Tansy had, that same weekend, filed an emergency grievance against me with allegations parallel to her Facebook claims, issued a dismissal of her complaint within 11 days as frivolous, retaliatory, and lacking even the minimal factual foundation required under MCR 9.112. Byron, meanwhile, made one more attempt at pulling political strings. He contacted State Representative Keith Dornbush, to whom he had donated $4,000 the previous cycle. Representative Dornbush, who happened to sit on the Michigan House Agriculture Committee, listened politely for 3 minutes and then said, Byron, before I do anything here, tell me something. Who is the lead defense counsel in the farm case? Some local guy, Vandermeer, Owen Vandermeer. There was a long silence on the line. Byron, I've known Owen for 11 years. He sits on the state GAAP review committee. He's argued 2 cases before the Court of Appeals for the Farm Bureau. He won both. I am going to tell you the same thing I tell every constituent who calls me in a panic about agricultural regulation. You should call your lawyer, not me. And Byron, I'm going to remove myself from your donor outreach list this afternoon. Please do not call back on this matter. Representative Dornbush hung up. He then, I am told, called Ellery Ray Bostwick directly and said, Ellery Ray, heads up. I just had the most interesting constituent call. Tansy, separately, called Piatt's high school principal, a 59-year-old woman named Rosalind Kelp, and left a voicemail claiming that Piatt had a violent meltdown on the Shaw property and yelled at me in a frightening manner, requiring me to lock myself in my car. Piatt, at the time of the alleged incident, was at school in geometry class with 21 classmates and a teacher. Principal Kelp, who had been Pete's IEP administrator for 3 years and who had never heard him raise his voice, reviewed his attendance records, time-stamped the voicemail, and called me. "Mr. Vandermeer, I thought you should know. I am also going to forward this voicemail to the sheriff's office, with your permission." "Mrs. Kelp, yes, please do. A takeaway worth writing down and keeping with your important documents. Almost every state makes it a crime, misdemeanor in most, felony in a few, to knowingly make a false accusation of a disability-related incident against a minor child, to school administrators or police. The reporting statute varies. The criminal exposure is real. Document the call, preserve the voicemail, file the report." Sheriff Trinity Forsberg opened a third file on Tansy Whitlock Shaw that Friday afternoon. Piet, when I explained the situation to him that evening over dinner, nodded slowly, thought about it for 45 seconds and said, "Dad, she's behaving the way a pattern does when a pattern is about to break." I said, "Say that again, son." "A pattern breaks after it repeats a specific number of times. You can see it happening." I looked at Henny. Henny looked at me. "Piet," I said, "that is the most accurate sentence anyone has said at this table in 6 months." He ate his peas. 2 weeks before the court hearing, Tansy called a press conference at her half-built house. She had arranged it through a Muskegon public relations firm she had retained at a rate Ellery Ray later estimated of $2,000 for the event. Invitations had gone out to 11 media outlets. 7 reporters showed up. So did a large golden retriever puppy named Baxter, whom she carried into the press conference like a purse. I was not there. I was, at the time of the press conference, sitting on a tractor 500 yards east of her house, mowing the alfalfa strip between my cherry and apple blocks, wearing ear protection and an Oceana Cherry Days cap my father had gotten me in 2006. I was, however, entirely within my rights to record anything said at a press conference held on land the Whitlock Shaws owned, from my own property, using a commercial zoom lens from a Cabela's tripod, which is what Piet, who was homesick with a minor cold, did through the west barn window with my own camera. The press conference lasted 8 minutes and 43 seconds. Tansy called me, in order of frequency, a bully, the worst kind of heartless businessman, passive-aggressive, and a man who cannot process grief in healthy ways. Baxter the puppy bit the microphone during minute 4 and had to be swapped out for another prop, a silver-framed photograph of her 3 children, none of whom actually live with her full-time. Piet, without prompting, clipped a quiet 4-minute highlight reel of the most actionable statements that evening on my editing laptop. He burned it to 3 USB drives. He labeled each one in careful block lettering. He handed them to me at the breakfast table and said, "Dad, in case you need these." Piet, thank you. I have also time-stamped the edits and noted the original file locations. I see that, son. 3 days later, Tansy drove her cream Range Rover to the Shelby Hardware parking lot, where my Ford F250 was parked outside while I was buying galvanized roofing screws. She got out. She walked up to my driver's side door. She keyed my truck from the door handle across to the rear fender in a single slow motion. She got back in her Range Rover. She drove away. My truck was parked directly underneath the hardware store's outdoor security camera. Sheriff Trinity Forsberg, when I presented her the footage 23 minutes later, stared at the screen for approximately 9 seconds, looked at her deputy, and said, "Well, that certainly saves us a lot of paperwork." Byron Whitlock Shaw was served that Friday afternoon with 2 different legal filings. One was a civil complaint for conversion, trespass, and tortious interference. The other was a formal notice from the Michigan Judicial Tenure Commission, informing him that his golf partner county commissioner, Arthur Penrose, was under formal investigation for conflict of interest related to paused enforcement actions. Byron, I am told by the process server, went white. The harvest came. I did what farmers do. I brought in my crew. I worked 14-hour days. Pete worked the culling line on weekends. Elsa drove up from East Lansing twice more. Henny handled the insurance paperwork in the evenings. The herbicide-damaged trees were triaged. 22 were saved with aggressive pruning. 18 would have to be pulled in the spring. 6 we lost outright. Piet's own grafted Honeycrisps, the ones he had watched me call his life's work in his 4-H application 3 years earlier, survived. All 40. He pruned each one personally, over 2 slow autumn Sundays, while the radio in the tool shed played a baseball game with the volume down. On the Sunday before the court hearing, I stood in the cherry block at dusk, with a cup of coffee, and watched the sun set over my grandfather's Norway maples. The air smelled of wet leaves and faint apple cider. A hawk turned slowly over the upper orchard. I did not cry, because I had cried already, months earlier, in the barn the morning I had found my father. But I did stand there for a long time, and I thought, Dad, I am going to end this on Thursday. The Oceana County Circuit Court sits in Hart, Michigan, on the second floor of a limestone courthouse built in 1913. Judge Patience Bloom had been on the bench for 11 years. Before law school, she had spent 9 years as a Michigan State University agricultural extension agent in 5 counties, including Oceana. She had known my father. The hearing was set for 9:30 on a Thursday morning. By 8:50, every seat in the public gallery was taken, and the overflow had filled the hallway. The Michigan Farm Bureau had put out a bulletin. Cherry growers, apple growers, dairy farmers, and blueberry producers had driven from as far as 4 counties. The Detroit Free Press had sent a reporter named Gwendolyn Miles. The Shelby Record had sent its only reporter, a 23-year-old named Cyrus Fogel, who had never covered a courtroom case in his life. I arrived at 8:52 with Henny, Piet, Elsa, Ellery Ray Bostwick, and Mrs. Hilda Peterson in her 1994 Buick Century. We filed in together. The hallway parted for Mrs. Peterson, who, at 86, walks with the dignity of a woman who has fed 4 generations of farmhands. Tansy Whitlock Shaw sat at the plaintiff's table in a cream silk blazer and a pearl necklace I am fairly certain she had purchased the previous afternoon. Byron sat 2 rows behind her. Her attorney Barrett Locke was reviewing a last-minute response he had apparently finished at 3 a.m. Judge Patience Bloom took the bench. She read the motion caption. She looked up at Barrett Locke. Counselor, I have your opposition brief. I also have Mr. Vandermeer's motion to dismiss. Before I hear argument, I want to ask you one question. Are you aware of the Michigan Right to Farm Act? Barrett Locke hesitated. Your Honor, generally, yes. Are you aware of its Section 3 preemption provision? Your Honor, are you aware of the 2018 Court of Appeals decision in Hall v. Northwood Estates, which I can see was argued and briefed by counsel sitting at the defense table? Your Honor, my client, Mr. Locke, I'm going to allow you 30 minutes of argument. I am not entirely certain why you are going to use them, but I will grant you the courtesy of the time. He used 17 minutes. Ellery Ray Bostwick, at 73, used 11. He walked through the 1867 deed, the 1854 Turnpike map, and the 1872 abandonment, the 2009 GAAMP registration, the 47-page Piet Vandermeer drift damage report, which Judge Bloom accepted into the record, the press conference highlight reel, which she also accepted, Mrs. Peterson's affidavit, Patrick Nells's preliminary MDA enforcement finding, the EGLE and soil erosion stop work orders, both issued the previous week, and the sheriff's file on the keyed F-250 with still frames. At the end, Ellery Ray paused and said, Your Honor, this case is not close. This case is an attempt by an HOA resident to convert a 5-generation Michigan family farm into her personal driveway, and when she was politely asked to stop, to bankrupt the farmer through litigation she had no right to bring. Section 3(6) of the Right to Farm Act exists for exactly this situation. We are requesting dismissal of the complaint with prejudice, plus reasonable attorney fees and costs, in the full amount of $287,400, as submitted in our fee petition. Judge Patience Bloom did not retire to chambers. She issued her ruling from the bench. The plaintiff's complaint is preempted by the Michigan Right to Farm Act. The motion to dismiss is granted with prejudice. The defendant's fee petition is granted in full in the amount of $287,400, payable within 60 days. The plaintiff is further ordered to vacate the asphalt encroachment on the Vandermeer Agricultural Hall Road at her own expense within 30 days. Mrs. Whitlock Shaw, Mr. Whitlock Shaw, I want you both to understand. You did not merely sue the wrong farmer. You sued a farmer whose professional life's work is the exact statute you have now discovered. Court is adjourned. Tansy Whitlock Shaw made a small sound that I would not call crying, and would not call laughing, and which I will not describe further here. Outside the courthouse, Gwendolyn Miles of the Detroit Free Press asked me for a comment. I thought for a moment. I looked at Piet, who was standing beside me holding Mrs. Peterson's arm. My father, I said, used to tell me there are 2 kinds of neighbors. The kind who help you put the hay up when the storm is coming, and the kind who do not. He and my mother spent 53 years helping. I'm going to keep doing what they taught me to do. Thank you. I walked to the truck. Piet got in beside me. He had been holding Piet's 47-page report under his arm the entire hearing. He set it carefully on the seat between us. Dad. Yeah, Piet. That went the way a pattern breaks. Tansy Whitlock Shaw did not pay the $287,000 judgment within 60 days. Her attorney filed a motion for extension. Judge Bloom denied it. A wage garnishment order followed. Byron's real estate brokerage revenue stream, which had been the primary income source for the household, became subject to quarterly withholding. The asphalt driveway was removed by a Newaygo contractor within the court-ordered 30 days, at Tansy's cost of $41,000, which she paid by liquidating her retirement brokerage account. The 1863 granite survey monument was professionally reinstalled by the Michigan State Historic Preservation Office, who added a small bronze plaque noting its inclusion on the Michigan Historic Landscape Inventory. Mrs. Hilda Peterson attended the reinstallation ceremony with a lemon bundt cake. The EGLE stormwater enforcement added $16,000 in civil penalties. The Oceana County soil erosion case added $22,000. The MDA pesticide drift case settled for $165,000 because Tansy's landscaping contractor's insurance carrier wanted to close the matter. I collected the insurance payment on behalf of the farm. The Whitlock Shaws put their half-built Orchard Ridge home on the market 91 days later. They moved to a rental apartment in Grand Rapids. Tansy deleted her Facebook. Byron's golf partner, county commissioner, resigned the same quarter. The Muskegon Country Club has not seen either of them since. I did not keep the $287,000 for myself. Ellery Ray took his rightful share of the fees, because he had earned them. Piet's share went into a college trust in his name that will sit untouched until his freshman year at, he has already decided, Michigan State University, studying horticulture. The remainder, $118,000 after legal costs, founded 3 things at our kitchen table over 3 evenings in December. The Dirk Vandermeer Memorial Fund. It provides free legal defense to Michigan farmers of any size facing nuisance suits from adjoining HOA developments, administered by Ellery Ray's firm at no personal profit to the firm. Mrs. Pedersen volunteered to be the first board member. My son accepted her vote at a dinner in her dining room, which meant more to Pete than I can explain. The Elsa Vandermeer Honeycrisp Grant. It funds Michigan State University horticulture scholarships for rural Michigan students. Elsa is, herself, the first recipient. She is also the first to announce, after receiving the scholarship, that she intends to pursue agricultural law at the Detroit College of Law after graduation. Her acceptance paperwork came home that Christmas. The Piet Vandermeer Youth Agriculture Program. It supports 4-H students with disabilities who want to pursue professional agricultural careers. Piet co-designed the application forms. He picks the annual recipients. He attends the awards ceremony every year in a white shirt my wife irons for him on Friday night. In the spring, we replanted the herbicide-damaged block. 150 heritage variety trees from Grandpa Dirk's original Budwood library. Honeycrisps, Spartans, Northern Spies, a dozen grafts of a variety my great-grandfather called Old Schmidt that no commercial nursery carries anymore. Pete grafted each one by hand. Elsa drove up from MSU 2 weekends to plan alongside us. Henny brought out thermos flasks of coffee and egg salad sandwiches. Mrs. Peterson brought Kroomcock. The new HOA president at Orchard Ridge, a retired school counselor named Louisa Westerkamp, walked up my driveway in June with a plate of oatmeal cookies and an apology letter signed by all 62 households. We negotiated, at my kitchen table, a modest, properly recorded public walking easement for HOA residents along the south margin of the farm road. Foot traffic only. No dogs off leash, no driving. Mrs. Peterson now walks it every Sunday afternoon. 3 HOA children have learned to graft from Piet on summer mornings. On the first anniversary of my father's passing, in December, I stood in the barn alone for a quiet minute. I said out loud, "Dad, it is finished." Then I went back to the house. Henny was making bread. Piet was reading at the kitchen table. Elsa, home from college, was grinding coffee. The fire was on. If this story has a lesson, it is that the farmer your HOA neighbor decides to cross may not be the farmer they think they are crossing. If you have a grandfather's filing cabinet in a barn, open it this winter. And if you have your own HOA story, share it in the comments. I read every single one. Subscribe for next week's story, where a suburban HOA decides a widow's family mineral rights belong to the community and runs straight into a 100-year-old deed clause nobody bothered to read. I'll see you there.
What made Tansy Whitlock so lose wasn't the asper itself. It was her certainty that nobody on a quiet Michigan farm was keeping records. She mistook Owen's bereavement for weakness. She mistook his son's Asperger's for a liability. She mistook an 1863 granite monument for landscaping. And she never once asked before she built an iron gate across somebody else's property, whose profession that somebody else actually practiced. Owen's real advantage wasn't his law degree. It was his patience and his father's example. A man who had spent 20 years quietly helping other Michigan farmers defend their operation found himself having to defend his own. And every document his father had taught him to keep lined up exactly where he needed them. His son's 47-page damage report, collocated in a 16-year-old careful block letters, became the cornerstones of a $287,000 judgment. If you live in a state with a Right to Farm Act, know your status this week. Drop your own HOA story in the comments. I read every single one. Subscribe for next week, where a suburban HOA decides a widow's family mineral rights belong to the community, and runs straight into a 100-year-old deed clause nobody bothered to read. See you there.